It started, already started. In another 2 to 3 minutes, you just check it. Huh? Okay. Okay. மெயிலில் இருக்க லைவ் கான்டாக்ட் இதுக்குலாம் அந்த லிங்க் இருக்குல்ல, அது கொண்டு சொல்லி அனுப்பிச்சிட்டாங்களா?
இல்லை, அங்கே மெயில் ஐடிஸ் கொடுத்தாங்க, நம்ம அது கொஞ்சம் டிலே ஆகும்.
அது லைவ் ஸ்ட்ரீம் ஆகும் அந்த லேப்டாப்லேருந்து.
அது ஸ்ட்ரீம் ஆரம்பிச்சு
ஸ்டார்ட் பண்ணிட்டாங்க.
இதில் நாங்கள் சும்மா ஜஸ்ட் ஃபீட்ஸ் செக் பண்ணிட்டு இருக்கோம். ஸோ ஹவு டு ஸ்ட்ரீம்
இது பார்த்துட்டு இருக்காங்க.
பார்த்துட்டு already 3 watching. Good afternoon. Okay. 3 watching. 3 watching.
அதில் போட்டிருக்கல ஒரு சேனல். வருமே மொத்தம் 9 பேர் வரும். 11 மொத்தம் 12 நினைக்கிறேன்.
ஜஸ்ட் ஒரு இது சொல்லிடுறேன், வெல்கம் சொல்லிட்டு இதில் சொல்லுங்கள். நீங்கள் ஆடியோ வீடியோவே சொல்லுங்கள்.
It should be for 5 minutes. All over. Yeah, started to run.
Only 3 of them.
In that one week, only 2 actually.
One student from Jodhpur is messaging me. Sridhar Mehta.
Okay. Sridhar.
Yeah, he's in Jodhpur. No, Bombay. He's based in Jodhpur. He's asking, has the session started?
You can ask him to just log in to the link.
Pre-recorded videos is going on.
அது போயிட்டு இருக்கு. Evidence.
No, I'll ask him to check now.
Just ask him to.
Because he has sent about 10 minutes ago.
Yeah. Evidence validation. Now it's streaming is going.
Started streaming.
இதுதானே பார்க்கணும்.
நீங்கள் இது பார்த்து அது நம்ம கொஸ்டின்ஸ் வந்துட்டாங்க. அவங்க தான் கேட்டுட்டு.
Refresh பண்ணுமா?
Okay.
You're watching the other videos. One person has asked.
36 minutes back we had a live session. So they were watching. நம்ம அது இன்னும் ப்ரைவேட் பண்ணது.
அதனால வரும்.
அதனால அது ஸ்ட்ரீம் ஆகிட்டு இருக்கும். ஸோ அண்டர் அது கீழே இருக்கும், லைவ்னு அது கீழே இருக்கும். அதை கிளிக் பண்ணணும்.
Most of you or your batsmen, they're doing about writing.
Sridhar and Professor Sridhar. Because Sridhar has been with me from ARM. Okay. ARM, ARF, and now
Sridhar, then Bangalore person. Dhanush.
Dhanush. Yes.
Presentation, physical comprehension. Content. Very good. I'm a deal. ஜாயின் பண்ணாங்க தெரியும். 3 நேடா இல்லைன்னு அப்படின்னு போட சொன்னேன்.
அப்படியே mail IDsலாம் வாங்கிடுவாங்க.
Good afternoon. I think at present we have two people online, and one of our colleague, Mr. Rishi, is physically present here. Before others join, I think PowerPoint presentation has been shared with all the participants. I think totally 12 participants. Just have a look on all the slides, so that is just giving a basic structure how an award should be. And when it comes to the actual arbitration award, it is bifurcated into two aspects. One is a technical aspect and another is a judicial aspect. And the examination perspective, it is shared into 60-40. That is, the technical part 60, judicial part is 40. That means you have to concentrate much on the technical part. And you all have just a reading on it. I think another Mr. Sridhar has connected. 3 people, 3 plus 4, 1, 4 people are connected. Have a look on the PowerPoint presentation and the other basic material what you have just looked into the earlier course books and the Bar Act also. Five people are adding on. 5 people. 4 number. என்ன ஆன்லைனில் வந்து 11 பேர் மொத்தம் 12 தெரில யாரும் இன்னும் ஒரு ஃபிசிக்கலாக 4 பேர் வரதான் சொல்லியிருந்தாங்க. You don't have a group message. WhatsApp group among yourself. Since the camera is here, I have to look there also. கொஞ்சம் நீங்கள் keep the light காணாது.
So I should
you can come here. It will make view easy. System கூட நீங்க அப்படியே
I push it some more.
lengthy இருக்கு. Easy. இப்படி No, so it's fine this side. Huh? It's fine because this will get stuck in this laptop. It's fine. Fine. Some error showing, we'll restart and reconnect.
Refresh.
Can we have a small session before the award rating actually begins? Sridhar has the doubt. Sridhar, I think I couldn't understand what is the meaning of a small session before. Is it a tea session or a coffee session?
Today is that session. Whatever you want to have it today.
We like to have a small introduction, I think, among all.
Some last minute outs.
To improve understanding as to what to write other technical aspects.
That is what this tutorial is about.
சொல்லிடுறீங்களா மெயில் ரிமைண்டர் சொல்லிடுறேன்.
ஃபோன் கொடுத்துருப்பீங்களா?
ஆமாம் கொடுத்துட்டேன் அவங்க என்கிட்ட ஜெயமேடம். Sridhar has a lot of doubt. What is the pass ratio in the award rating? %. Yes, asked for ratio. I given the percentage 20. சொல்லிட்டேன். நான் இது மெயினாக இது நான் ரீட் பண்ண எல்லாருக்கும் இது கூட இருக்க மாட்டேன், இது ஷேர் பண்ண முடியாது.
நம்ம எல்லாருக்கும் போட்டு நம்ம பாருங்க, சிம்பிள். ஒரே லிங்க் ஸ்டார்ட் ஆயிடுச்சு செஷன்.
You just pull it further also. இங்கே இருக்கு ஒயர் லென்த் இருக்கு. Another 2 minutes I will start. Yes. No purpose for waiting. If they want, I'll just have a introduction.
No, they can. Similar to the live last level. They can say the earlier minutes also.
Earlier.
So we can just
move the cursor.
They can see.
Record ஆயிடுச்சுப்பல்ல.
Oh, record ஆயிடுச்சு.
Pre-recorded மாதிரி அவங்க பார்த்து
record ஆயிடுச்சு. அது நம்ம
It's like
somebody
default.
comes.
We can ask them to just have a read. After completing, you can ask.
Like a default live.
Not even after completing.
Before that.
While the class is going on,
they can start from behind.
Okay, behind.
So when we are giving a break, continuous
they can catch us.
Catch us.
6. One more I said.
Totally 12 அல்ல.
12. உங்களோட சேர்த்து 12.
In case there is a 30 minutes delay, we can share them the link.
I'm really sorry, sir.
Like to have some coffee or tea? ஆரம்பிச்சுங்க காஃபி டீ. I won't take, that's the reason.
No, sir.
Did you receive the mails with the PowerPoint presentation?
Yes.
Four have to join. இது கட் பண்ண முடியாதுன்னா ஃப்ரெஷ்ஷாக தான் இருக்கு, அப்படியே தான் கண்டிப்பாக பண்ண முடியும்.
Session நியூ செஷன்
நியூ செஷன் வேணாம், டிஸ்டர்ப் பண்ணலாம்.
இன் கேஸ் அவங்க பார்க்கணும் நம்ம edit பண்ணிக்கலாம்.
ஒரு 2 பேர் join பண்ணிட்டோம், we can start another 2. Yeah, already 5 there, 3 are here, 8 plus another 2. கோரம் இல்லை என்ன கோரம் இல்லை, அதுக்கப்புறம் குவாரல் ஆயிரும் அது. என்ன சம்டைம்ஸ் மைட் பி ஆங்ஷியஸ் பீப்புள். அவங்க வந்து நான் வர வரைக்கும் ஏன் வெயிட் பண்ணணுமே, சிஸ்டமில் ப்ராப்ளம் இருக்குது, they might raise some issues. we can manage it, but unnecessarily என்ன இஷ்யூ நம்ம கேட்கும். இப்போ வேறு
நம்ம ஃபேஸ் பண்ணியிருக்கோம்.
we had first time இல்லை அதுக்கு முன்னாடி first time
I've seen this quarrel in the group itself.
Someone from she was in a car.
அது ஒன்று மெயினாக யார் தெரியுமா, அவங்க ஃப்ரெண்டு தான் பிரீத்திஷா. பயங்கரமா ஐயோ என்ன சண்டை போட்டாங்க. ஹவு கேன் யூ டூ லைவ் ஸ்ட்ரீமிங் எல்லாம், ஐ பெய்ட் ஸோ மச். இதே தேவையில்லை, இட்ஸ் ஜஸ்ட் அன் ஆட் ஆன் திஸ் அவார்ட் ரைட்டிங். பட் ஷீ டிட் வெல் இந்த எக்ஸாம். இருந்தனால அது பெரிய இஷ்யூ ஆகிட்டாங்க. The good thing is that we are going to have a South India chapter of CM. The year end. The board has given the clearance. The headquarters board of trustees have to approve the stage.
Separate questions.
Yeah, South we can exclusively deal. So actually, people from this region only are actively participating.
How do you suggest us to prepare for this award writing?
Just Sridhar wants to start. That's the tutorial is all about. Okay, fine. I think reasonable numbers are here. 8 people are here. 3 people basically Mr. What Lal sir? I forgot your name. Rishi. Mr. Rishi, Harita, and Bhavna. 3 are here, and I think others are likely to join online also. Fine. Today we are just going to have a small deliberation about how to be prepared for award writing examination. What are the requirements for an award writing? Fine. Generally, looking upon whether the Model Law or the Arbitration Act, it doesn't specify how an award has to be drafted. It just says that an award should have such a form and the content of the award. And the major condition, if you see on that particular provision, that is Article 31 of the Model Law as well as the Section 31 of the Indian Arbitration Concession Act, it starts with that it has to be in writing. Obviously, your award is going to be in writing. Fine. Second, it is mentioning that all the members of the tribunal have to sign that particular document or the award. Fine. If it is one arbitrator, it is going to be his own signature. If it is going to be more than one, there are 3 arbitrators. The expectation of the law is that all the 3 have to execute that particular document. It is very important when you are writing the award writing, whether it's domestic or international, the fag end of the arbitration award, you have to place the signature. It is not required that we have to sign in all pages, like normally in affidavits or in courts we have the types of documents. All we usually come to the practice of signing in every pages. It is not like that when it comes to award. An award should possess the signature of the members, but it is required in the final stage. If it is more than one arbitrator and if one of the arbitrator is dissenting, whether you can expect that person to sign, or whether at least in the award writing examination, whether you can ask that arbitrator's signature also to be placed there? No. In such a situation, a small portion beyond that has to be prepared by way of dissenting portion of the award. It might be even a half page. Just put the dissenting and then that arbitrator alone would place his signature. This is a normal structure according to the Article 31. It has to be in writing, it has to be signed. Third condition. Specifically, the place or seat of the arbitration has to be mentioned in the final page of the award or the completion along the signature, the place or seat. Normally in international arbitration, subject to how your the scenario comes, assuming that it's an international arbitration. In international arbitration, the place and the venue might be several and the seat would be one. Which one we have to place? The understanding of the law is that the seat alone has to be mentioned. It can be prepared in any place, but the seat alone should be mentioned. Don't ever try to put the venue or place there. If you're going to try to put the venue or place, then you're going to lose at least 3 to 4 marks. And it is good in a real-time arbitration also to mention only the seat, because the seat creates the jurisdiction. In both ways it will be helpful. Examination perspective as well in real time it will be helpful. Okay. This is the third. Fourth aspect of an award, a structure of an award, the award should be legible. Legible in the sense that the style, the structure of the award, how we are going to structure the award. Normally if you see, we don't have a template for an award. Normally we will come across many judgments in journals. Just take the judgment. How the judgment starts? The judgment has a cause title. Then it will mention about the parties' details, their addresses, their representatives. That is the initial structure, or like a preamble, a structure, a cause title will be given. In arbitration also, you make that structure. Have a cause title with the mentioning of the parties' names and addresses, as well as mention the representatives' details and their addresses. That is very much required. Fine. This is the first structure of the arbitration. Fine. Further, in the same article, can you find any other suggestions are there how to formulate an award?
31.
31. Article 31.
Reason. Reason.
It has to be with reasons. That means there should be a portion for providing the reasons or observations or findings. All synonym. Observation, reasoning or finding. Either way you can just put a title and you can share it. Okay. What other things you can add on when you look on 31? It speaks about interest. Don't miss the interest and cost. Luckily now the Indian Arbitration Act has suggested 31 capital A, wherein a separate regime of cost is mentioned. But normally looking into 31, it is just cost. Give a portion of the award for cost. What you have found here is that it has to be in writing, it has to be signed by all the members, it has to mention the place, that is presumably the seat of the arbitration. It has to be in a proper structure with reasoning or observation or finding, as well as the cost. These are the very basic ideas what has been, it is not requirement, it's just an idea given by the Article 31 of the model law as well as Section 31 of the Act. Now, task is left to us how to formulate the actual award. We don't have a format or a template. Okay, an award should have basically two areas. One is called as the technical aspect and another is the judicial aspect. Kindly all in online also kindly note down these points. It's very important points. Step by step I will give it. First, technical aspect. Under technical aspect, there are three subheadings. One, identification. Two, the operating part of the technical aspect. Three, the style. Okay. Before looking into these three headings or subheadings, there is a basic requirement for any award under technical aspect. One, reference to the arbitration law. These are under a technical aspect. The first one, reference to the arbitration law. Second, reference to the arbitration rules if specified. Reference to the arbitration rule if specified. And finally, the parties including their titles. Parties including their titles. If you carefully look upon these two, particularly the last one, mentioning of the parties including the title is very simple. A party should have a capacity to arbitrate. If a party doesn't has a capacity to arbitrate, obviously that award would be set aside. The first condition under Article 34. That is the very purpose that when you are going to mention the technical aspect, we have to clearly mention the capacity of the parties. And finally, the point under technical aspect is the title pertaining to that award, whether it is a final award or partial award on a specific issue. As a recap, under technical aspect, we have three headings. One speaking about identification, two speaking about operating part, three about the style. And as a preamble in the technical aspect, we have to look upon mentioning about the arbitration law, mentioning about the arbitration rules if any specifically required, and third is the details of the parties or the capacities of the parties. And further, as supporting mechanism, the title. Normally, when you are writing the award or the examination, we have to mention clearly final award. And if the scenario gives for a partial portion to be decided, you mention partial award. That carries a good mark. Because an award, if you look on the PowerPoint presentation, there are certain categories of arbitral award mentioned. One is a final award, two is a partial award, and three is award on agreed terms. That is the settlement award. Which one you are going to take? Which one you are required to reproduce? That is very much required. If it is clear that it has to be a normal award, mention it final award. If it is going to be answering a specific issue alone, you mention it as a partial award. If it is based on any settlement, it is award on agreed terms according to Indian Act. But when you look on the international perspective, it might be consent award also. Depend upon the material what has been given, you just give the title. But don't miss the mentioning of the title. Okay. Coming into the identification of the technical aspect. The first point, you have to reproduce the arbitration clause. An abstract of the arbitration clause should be there in the identification when it comes to technical aspect. It might be even one page, the arbitration clause, but you have to write it. For exam or in real-time arbitration, the arbitration clause should be there, because when an award is being taken to the courts under Article 34 or Section 34, we can't expect the judge to look upon the original contract, the arbitration clause. They'll simply look upon only the award. That means the mother document, that is the arbitration clause, should be reproduced here. Okay. First, arbitration clause or an agreement should be an abstract of it, has to be reproduced. Second, the appointment process of the arbitral tribunal. How the arbitral tribunal, whether sole or three-member, how they were appointed. Whether the parties agreed, or whether the parties nominated, or whether the courts are appointed under Section 11, or finally whether an arbitration institution appointed the arbitrator. If it is ad hoc, it will be the court. The court appointing default appointment. If it is institutional, the default appointment would be the institution. it varies. But the initial 2 points, parties have the first right, clearly mentioned who has appointed who. There might be 3 arbitrators or even 5 arbitrators, but we had to clearly mention who has appointed, which party has appointed, and how the presiding arbitrator also was appointed. That process, the nomination of the arbitrator tribunal is required. Why? Because another section 34 speaks about improper service of notice pertaining to appointment of arbitrator, as well as improper composition of the arbitral tribunal. 2 grounds are there in Article 34 which should not be attracted in this award. One, how the arbitrator was appointed, whether under the proper mechanism suggested by law. Okay, if you are going to mention it clearly, no issue. Second, whether the numbers are in accordance to the agreement as well as the qualification. That also would be clarified when you mention the appointment process.
So when we write these particular clauses, we write it in third person. It's as if like, this arbitral tribunal was constituted. We write it that way because the presiding arbitrator.
If you are going to have more than one arbitrator, it is always better to mention this arbitral tribunal. The arbitration award would be prepared by 1 or 2 or even all the 3. But it is always better to mention this arbitral tribunal. If it is sole arbitral tribunal, you mention I. That is better. Second, the appointment process. Third, you have to mention the actual date of contract. The contract date. The parent document which possesses the arbitration clause.
The contract date.
Date of the contract. If it is mentioned, reproduce here. All these are technical, not judicial. Fourth, what is the prayer? Claim. What remedy they are seeking? That has to be very clear in a summary way initially. These are all initial aspects. The summary of the claims. Then 5. As I earlier mentioned, the place or the juridical seat. Next, very important. Anyway, earlier I mentioned in macro, now micro level, very important is that identify the various laws applicable to the contract as well as arbitration. 1. Applicable law for the arbitration - Indian Arbitration Conciliation Act 1996 based on the seat. 2. Substantive law applicable to this arbitration, Indian Contract Act 1872. If it is different, if it's a French code or German code, whatever might be, you mention that. This clarification is very much required because most of the arbitration clause, the parties would have not agreed actually for the governing law, applicable law, the substantive law. But in the arbitration proceeding, the arbitrator would have decided upon that. That has to be reflected in the award by way of an additions mentioning that identifying the various laws applicable to the contract and arbitration. This might be very basic, but it is very much required. There shouldn't be any anomaly. Which law is applicable? You mention it. Next point, the cause of action, the actual dispute. Because you can see in some of the arbitration or the scenarios, one of the party would have been putting a point challenging the jurisdiction of the arbitrator, saying that there is no dispute at all. It is premature that the parties have invoked the arbitration. If such a position is being taken by one party, to just overcome that, the arbitrator has to mention what is the dispute or there is a cause of action. Why this tribunal was constituted, that portion should be there in a small, all these are just small paragraphs, initial paragraphs you have to produce. Next, the parties' details including their addresses. It might be repetition, several occasions, but you have to do it. Parties, details as well as their addresses. Here, when it comes to address, which address you will place?
So there, if it's like a company, it's the registered company's address.
Yes, company registered. If the company has a business address, principal office, branch office, which one you are going to mention in this arbitration?
Whichever is in the agreements.
Which is in
Whichever
agreement.
is the party of the agreement.
Okay.
For example, sometimes it's a subsidiary which is a party to the agreement. So the subsidiary is a place of business which is mentioned in the arbitration agreement will be mentioned here. And individual, again, the contract will provide the address wherever that individual lives or resides or working on.
Here comes smartly as an arbitrator, we might know about this, okay, fine, the contract is mentioned clearly, but the parties in their pleadings would have given a different address. It is always better for us to just adopt what have been given or the pleadings what they have just mentioned in their pleadings. There might be various exhibits. Those exhibits might mention about the principal office or the registered office. Don't seriously look upon that. Just look upon what address they have provided before this tribunal when it comes to filing of the pleadings. That address alone should be there. If you are going to mention the registered office, and obviously if the registered office is just an office wherein which is receiving some letters and replying, sometimes there won't be any person even to receive that. Don't take a chance. You just, what they have made in the pleadings, there might be in moving of the registered office from one place to another, yet to be reported to the ROC within a month. But you be very clear, only the address given by the parties in their pleadings. Then the procedural matters. How you conducted the arbitration in a chronological list. When you write an award, particularly in the award writing examination, you make a tabulation of the procedures. Assuming that we are on 7/7/2018, the arbitrator appointment letter. Second, 11/7/2018, the arbitrator invoked the arbitration. Likewise, subsequently, the arbitrator would have several hearings. If you have some inputs based on the scenario, you reproduce on those. And when the arbitrator completed the final hearing and reserved this matter for award, make a chart. It might be even 3 or 4 pages, but you make it. This document should have all happenings, because there is possibility of one party challenging the award based on public policy, a misconduct of an arbitrator, or some unwanted activities of an arbitrator. That would be subject to challenge. If you have a clear picture of the procedure would show very clearly that the arbitrator has adhered and given equal opportunity to the parties, heard the parties, and then reserved the matter for award.
Like, for example, he called for the first procedural hearing.
Yes.
They met to decide certain logistics.
Ascending order.
Everything.
Ascending order. Very simple.
Submissions,
Yes.
rejoinders.
That's what, from appointment,
Till
then his preliminary meeting, then the procedural orders, interim orders also he would have given. All those mention it clearly, and when he completed.
The pleadings timetable we don't have.
And not record. Just the days and when, what
When it
happens.
was
That's
decided.
all. If you are going to mention a particular reasoning, or you are going to have a reasoning out of that, then you make it. Otherwise, there is no requirement. Fine. After that, the place and date of hearing. Place and date of hearing. Because the seat might be one, the place or the venue might be different. Wherever you happen to have the hearing, you mention the dates alone. On the particular date, the hearing happened, particular date. In international arbitrations, there is possibility to have in any part of the world. The seat would be India, but the arbitration would be happening in Singapore. Only for the purpose of award, the seat of the publication of the award is Singapore. Otherwise, it might be varying. Mention all those as a next tabulation stating the place and date of hearing. A small tabulation. Further, the representatives who are representing the parties, whether the parties are themselves representing or the counsels are representing the parties, their details. This is brought in, why? Because we have that IBA guidelines, no, on conflict of interest. Because of the counsel, there might be some issue. His relationship with one of the parties or his relationship with the arbitrators, some vice versa. Arbitrators' relationship with these persons might create an issue. Their mention should be very clear. Under what capacity? Assuming in international arbitration, there will be large arbitration law firms wherein their counsels would come, associate would come, partner would come. In the same law firm, in another branch office, a party counsel would come for the other side. He might be even the arbitrator. That conflict of interest aspect should be clarified based on mentioning who is representing the parties. Next, identifying the witnesses. If you have a list of the witnesses, you mention the name and their capacity. Okay. And further, simple aspect on technical aspect identification is heading, numbering, and physical presentation. All these aspects, whatever mentioned from arbitration clause till identifying the witnesses, you identify, but with headings, with numbering, as well as physical presentation. A small question by Sridhar. In place and date of hearing, do we have to mention only the final hearing, as we have already mentioned the hearings in the above table? Okay.
When you can't be mentioned.
When you are going to just mention the two aspects, one, we are mentioning about the procedural matters. In procedural matters, we are not going to give much importance about the place and the date. Henceforth, that will be separate. That is obviously separate. Henceforth, we don't have to mention only the final hearing. That tabulation solves. Video seems to be paused. Okay, there may be issue.
Refresh.
Okay.
Number is increasing also.
See, it's increasing and decreasing, increasing.
Increasing and decreasing. Okay.
Somewhere on
Fine.
the way.
This is an identification aspect of the technical part. Second, operating part of technical aspect. These are just I am giving randomly. Then you have to find out how, in which place we have to put it. Operating part, the very important thing is that whether interest is payable or not. This comes under technical, not judicial. Interest is payable with statutory obligations like GST or VAT. That should be mentioned. Second, date of payment of such interest. Date of payment of such interest. In international arbitration, a date or the period should be mentioned. From till which date. That mentioning is very much required. Don't miss out. Post award is automatic. It depends upon which jurisdiction you are. Whether the arbitrator is going to mention the interest or not, there is no issue on it. But prior to the award, it is left to the tribunal to decide, but they have to decide the interest, what interest is payable and what statutory tax obligation is there. They have to adhere to it. Mention the period. Don't miss it. Third aspect, after the date of payment, liability of the parties pertaining to the cost. That is the apportionment of the cost. Liability of the parties on the aspect of cost. Who is liable to pay the cost? The apportionment of cost. Fourth, liability for arbitrators' fees and expenses. That cost plus arbitrators' fees and expenses. Next, there should be mentioning of reimbursement aspect if it is required. Reimbursement. Normally arbitrators would intend to pay his travel or the expenses. They might claim it in the award as a reimbursement. That if it is there, you have to mention. And finally, if you are inclined to order interest on non-compliance, then you mention it. Interest on non-compliance of the aspect of cost. When the cost has to be paid in a particular period, if it has not been made, then we can mention interest. But in India, we are not using that practice. It is somewhat, it makes an adverse effect on the award, enforcement award. But in international practice, there is a possibility you have all authority to mention interest on non-compliance. This is the operating part of the technical aspect. And finally, the style, the structure when it comes to technical aspect. Obviously, this will be same in both technical and judicial. Style, first thing, your award should be readable. That means it has to be in simple English language and it should not have a lot of vocabularies, proverbs and quotations. Avoid quotations in an award. Avoid it. Kindly avoid it. Make it in very simple language, whatever language, whether it's English or French or Tamil, whatever you're going to do, make it very simple. Normal sentences. Don't stretch lengthy sentences. Lengthy sentences would create a trouble. It is not comfortable for the audience to read it. Okay. Layout and numbering. Numbering, what generally you have in mind? How we can number? Para number 1. Okay. Normally in arbitration awards, internationally it is always better to put 1.0, 2.0, 3.0. In 3, you have some further subheadings. Put it 3.1, 3.2. In that, if you have subheadings 3.2.1, 3.2.2. Is a very, very important numbering. You have a numbering because numbering makes the parties convenient to identify where we are reading, which clause we are referring. That is very much required. Put numbers. Even it is a one line matter, you give a number. That will be appealing. Okay. All these are coming under the technical aspect. Now, judicial aspect. In judicial aspect, there are totally four to five headings. One speaks about the general aspect of the law. 2, preliminary issues. 3, liabilities. 4, claim and counterclaim. Normally counterclaim is there, we have to separately deal with it, but we have to mention it. It's very much required. And 5, the legal cost. Anyway, it might be repeated both in technical and judicial. Coming to general aspect of judicial, identifying the relevant contract terms. When it comes to the findings of an arbitrator, they have to be very clear on the contract terms. Which contract the arbitrator is relying to look upon the admissibility, relevancy and materiality, and which contract clause the arbitral tribunal is going to depend to identify the breach or violation of the terms and conditions of the contract. That has to be very clearly mentioned in the reasoning part. Identifying the contract terms or the relevant contract terms. Second, identifying the agreed facts, that is the admissible. aspects. Admissible aspect has to be highlighted. Normally, if you look upon some scenarios, there will be some points mentioning about admitted liability, acknowledged liability. It's a very common. In some letters or correspondence, it would be there. If you are going to rely on that, you have to identify properly and reproduce under the judicial heading. Very much required. Then finally, identifying and formulating the relevant issues. If you are going to categorize 3 issues in that award, you mention the issues, look upon the contract terms, take the contract terms, agreed facts or admitted facts, then put your findings, and finally try to answer all the issues. This is very simple. Answering all the issues with your justifications. These are the findings. Reasoning findings is the basic general principle under the judicial aspect. Okay, 1. Identifying the relevant contract terms. 2. Identifying the agreed or admitted facts, including the liabilities, whatever might be. And 3. Bringing out the issues, identifying the issues and formulating the issues in an acceptable manner. Okay. These are general under judicial. Second, preliminary issues under the judicial. There might be several interim interlocutory applications, that is the challenge on the jurisdiction, like Article 16 or Section 16 challenge, then Section 13 challenge. All those in the preliminary stages, I think in the earlier modules and all, you would have understood that an arbitrator need not give a detailed order pertaining to Section 12, 13 challenge, Section 16 challenge. A simple one-page order is enough. Now, when it comes to writing an award, a detailed analysis of those application, the findings would be the same, but the analysis should be detailed. That analysis should be reproduced in the award, particularly all the interim interlocutory applications. Okay. Under this interim and interlocutory applications, there is an aspect of description, in the perspective of scoring. I am saying, no need to make note. Description, handling and weighing submission, whatever submitted by the parties, how the arbitrator is taking, which one seriously, which one is reliable, which is relevant, like that. All that has to be valued perfectly. Knowledge of law. We had the identification of the relevant laws, the contract terms, but how we are going to correlate with the issues, that is very much required. It might be even a single line, but it's very important. Application of the law to the facts and conclusions. How we are relying that particular provision in finding and determining that particular issue and giving a decision. It's a chain reaction. Identifying, analyzing and delivering. That you have to mention under the each and every heading, under the interim or interlocutory applications. Next comes the contract and liability. Here comes the evidence. How we are going to deal with the documents. Here the marking is based on certain aspect. One, whether the arbitrator has identified the issues clearly. Normally there will be 2 to 3 aspects combined in one issue. You should not make it. One example is that whether the respondent has done the breach of clause number so and so. This is one clear issue. If you try to make that issue, whether the respondent is liable for breaching clause 24,38 and whether the respondent is entitled for counterclaim. This is a somewhat an ambiguous issue. Be clear, be simple, split into, even it might be hundreds of issues, split it. Don't combine in one. That is very much required. Identifying issues clearly to handling and weightage of evidence. How we are going to handle and give weightage to evidence. That is how we are going to rely on the documents. Whether correspondences or any other document, or whether oral witnesses statements or depositions. Which one you are going to rely? You make it very clear, concise. Knowledge of law, obviously it has to be there. Application, conclusion of liability. Finally here, any other remedy. Have you seen in all the claims or counterclaims, there will be one aspect on as the arbitral tribunal feels fit and necessary,
Deems fit and
deems. Whether we have to answer that, you have to. If you are going to give or not, you have to mention. This tribunal feels that the above two issues alone needs to be answered and the parties are entitled for those claims. There is no option of any other claims to be decided by this tribunal. Close it off. Don't keep it open. Always close it. Then comes a counterclaim. Counterclaim also the same aspect. And finally, the cost. Okay. These are the basic structure on expectation of an award writing. One, the technical aspect. Two is the judicial aspect. Technical aspects covers about the arbitration clause and the basic procedures. And when it comes to judicial, comes on the aspect of issues and how we are interpreting the contractual terms as well as the issues which you are going to determine. All these, if you just produce, you can easily get a pass mark. Pass mark is 70.
Because technical aspect is almost 60%.
Yes, technical is 60. It's 60-40 ratio. That is why you have to reproduce all. The parties detail, representatives details, arbitration clause, appointment process, the interim orders, generally what the date when it was issued, procedural aspect, hearings, place, signatures, all these if you cover properly, then you can easily clear this. Not only that, in real-time arbitration also it works very well. Okay. Yeah, this I had given like a effective clue for examination, and now getting to this PowerPoint.
Just one query.
Yes.
Question. Not the format. They said that about 15 days before the award writing, we get the first part of the problem, and the second part is given
On the day of exam.
So it will be the same, relating to the same problem.
Yes, yes. One clarification as a colleague has asked. Before 10 days of the examination, that is on 17th exam, assuming that on 7th or 8th you will get a portion of the basic material. It's not a question, it's just a basic material for your award writing. You can leisurely at your place, you can make the preparation. Make it. Mostly many of you would go for the modem of using the laptops. You make it prepared. The other portion obviously would be on the annexures, exhibits and some documents which are missed out. It is anyway related. There is no irrelevant issues. Same problem as a continuation will be given. Not an issue on it. All of you just look into the PPT, PowerPoint presentation, wherein there is an award checklist. It's page number 5 or 6.
Essential of an award.
No, beyond that.
Yeah, award checklist.
Award checklist. Yeah. On looking into this particular slide, Can you just presume that all has been covered? It speaks about title, names of parties and status, that is the capacity of the parties, the contract, that is the contract date I was mentioning, no? Which contract you are referring. The arbitration clause, the disputes to be decided, that is the cause of action, the core, mature dispute. Appointment process of the arbitrator, that is the appointment of arbitrator, because that confirmation is very much required. Conduct of the reference, that is the procedural matters, the hearings, the place where you are conducting, that is the conduct of the reference. Then summary of submission, this is not mentioned earlier. It is always better for our convenience. Take it from the pleadings. What are the parties mentioned in the claim, the answer or the reply by the other party? You take a summary from that. You rephrase that and bring it in the award. It can go for maximum 2 pages. You make it so that you are not traversing beyond the scope of authority. Whatever has been claimed, whatever has been objected alone is being decided by the arbitral tribunal. To save that section 34 ground, we have to be concise with the summary of the submissions. Then reasoning, that is the finding on the facts and the law. Then the decision of the arbitrator, including the interest and cost. Operative direction, that is who has to pay who.
Descriptive portion of the
Hardly 3 lines. 3 lines. So that many people have the intention to go straight away on that page and look into. Oh, okay. Then only they look upon the other pages. That is also required. Whether it's domestic or international, that is required. Then comes the place or seat, and finally the date and signature of the arbitrator. A very simple thing, what I have just described into technical and judicial aspect. If you have this checklist in mind, and if you just after halfway of doing the examination, you just look upon or think about this checklist, all the things if you have covered, you can succeed.
The length and all of these things doesn't matter.
It doesn't matter, but when you are just going to give, assuming that with these inputs, surely it will come to 15 pages.
Definitely.
Minimum 15 pages. Maximum you try to concise with 25 pages. Sometimes some awards might stretch only because of this summary of submissions and reasoning. Summary of submissions, it is not your creation. It is not your ideas. You might rephrase that terminologies, but it has to be a reproduction of what has been given by the parties in a simple way for anyone to understand. That has to be the shortest version. Reasoning also should be even shorter than the summary of submission based on the issues what you are going to deal. Okay. There is another question on Mr. Venkataranga Rao. What if it is typed 15 pages also? Okay, I presume that he is asking whether it's typed or handwritten. Many candidates also go for handwritten. It's quite tough, but they are very successful. They all succeeded because they are very clear. They have to complete within the reasonable pages. Okay, but here the option is many were eligible also. It's okay, fine. I'll just later discuss about it. When it comes, it is going to be most of them going for type only. The pages you try to concise with 15, and the very interesting thing is that as writing an article or a literature, you give double space. Don't type in the back side. Just one page of the paper you type, double space, bold your headings. Headings is very much, all these are headings. The checklist what has given, these are headings. You mention those so that if you are not clear,
particular font size and all.
Yes, that it depends. Normally it is Times New Roman or Courier. That is standard. Don't go for Verdana, the like Italics version. Don't go for that. If you want to italize, you italize, but italize only the case laws if you are referring those content or some references in some judgments if you are taking. beyond this, some arbitration awards or some articles of the source, you just italize. Otherwise, don't italize and avoid putting footnotes. In an award, avoid putting footnotes. You are not writing an article, you are deciding. Some international arbitration awards, there are footnotes, but you simply avoid it. It is not good, at least in some jurisdictions. Yes. Some basic guidelines are given in these PowerPoints.
Yes. Initial.
I'll just go through quickly. I think all of you are having, no?
Yeah.
Fine. Any suggested reading before we take the examination? Okay, if you can afford 7,000 rupees, you can purchase the Rayner's.
No, sir, it's
Ray Turner's book on arbitration award. In LinkedIn, it is, sorry, pardon?
they've emailed it to us.
You got it?
Yeah.
Ray Turner's book.
Yes. It's item number 14 in the email which has come.
You got the book?
Arbitration awards, Ray Turner.
Ray Turner, yes.
Oh, the
We
entire
got two
book.
books. We got Ray Turner.
Okay, kindly
also.
share to me. I am not having it.
Yeah.
Okay,
Yes.
you have very
Item
important
number.
things. This Ray Turner gives, not all the books are suggesting about how an award should be there. They are given some guidelines how an award should be drafted. One Ray Turner on arbitral awards, I think you have received.
Yes.
Second, you look upon R40 arbitration award writing tools.
Sir?
ARB 40 R40 award writing tool. ARB 40.
It's a book, sir.
It is like a report given by.
Available on Google.
It is Google. You can Google it. If you are not getting it, I will share it to the registrar so that she will share it. Award writing tools.
This book, Ray Turner, is only 47 pages.
Yeah, that's what I said. Spend 7,000 to get 40. But I'm not sure whether it's an actual book content
So
they have shared.
what the module says here in the beginning, they say that for the purpose of this module, what is relevant from that book has been sent to you. But if you want to further read, you can
The
buy
entire book.
The entire book.
But
That's
it's
what they
my
say.
suggestion is that you look into the entire book.
Yeah. They have shared one more book. Oh, one more, two more books. One more book, three authors.
Okay. Some basic materials are there, but my personal suggestion is that you just take upon one judgment, court judgment, what you can find online. Look upon what's the structure of it, and with this checklist you can do easily.
So actually in the last modules which we did, they shared with us about 4 awards. One is Indo-Bangladesh.
Oh, you got that?
Yeah,
2 NSC awards we got.
Okay.
In fact, that award is very good.
Okay, but don't reproduce here.
No, I'm saying the format. Just for the format purpose.
Excellent. That style
Just to
and
understand
structure
the
and
structure.
the layout is very much easy.
Because like the
You
NSC
have to
award,
speak loud.
Yeah.
Sridhar's comment.
NSC award is only 15 pages, but it covers the structure.
Okay, Mr. Sridhar, Mr. Rishi, your friend wants to highlight that several 4 to 5 awards, model awards has been shared in various stages before this module, wherein those are very excellent to read once again, and if you want you can also memorize once again for your exam. That is Rishi's input.
So the other book that is shared is Comparative International Commercial Arbitration by Julian D. Liu, Lucas Mistrels and Stefan Micrel.
Okay, from the same Queen Mary
Same
University.
And again, this also relevant pages, 20 pages has been shared.
Okay, fine. Relevant pages.
Relevant pages. 20.
Okay, but these all are just, it's not a template or a format. Gives how it has to be structured. The structure is a combination of the checklist. Look upon the checklist. What the checklist is given is been taken from all these books. Nothing new or out of the way. Fine. Coming to the PPT, the PowerPoint presentation, enforceability of an award. It is very much required when it comes to structuring an award. Yes.
Which PowerPoint are you using?
Oh, the same PowerPoint.
No, number.
Number after the award checklist.
Yeah, enforceability.
Slide number
Why
7.
those are too technical in nature, especially marine engineering?
There is a spike guide. The spike guide well.
Not sure.
அதில் பக்கத்தில்
Mr. Rangarao, which one you are mentioning that they are too technical in nature? Can you just type it?
PowerPoint.
Yes,
material that they have sent us.
Huh?
In the material that they have sent to us.
Oh, so one is.
There is a workbook. At page 58 of the workbook,
Uh-huh.
there is one checklist. Formalities and
Okay, okay.
so maybe he's referring.
Oh, he is referring that.
Maybe. It covers what they are doing. So they have titled it as formalities and reason.
I mean about the awards given. Oh, awards given in module 3.
Yeah.
Oh, those are just sample awards.
Yes.
And for you to just have a basic idea
For
about structuring and the style of an award, how it has to be internationally accepted. But it is all your own creature. It is left to you. The only thing is that it has to be appealing, it has to be legible, it has to be clear, it has to be simple, it has to be relevant to the issue involved.
It should not attract 34.
Yeah. Finally, that's what an award has to be enforceable. That's what in this presentation I have just mentioned these. The remedies has to be within the jurisdiction of the arbitrator and the disputes referred. You should not go beyond what the parties have claimed. Okay. Second, it has to be clear and unambiguous. That shouldn't create another dispute. The reasons must be adequate, intelligible, and sufficient to enable any court to properly determine a question of law when it comes to appeals. All things revolve around the award should not be challenged easily. It should be capable of performance by the parties. And finally, the award should show the finality. It should show, otherwise the party should be successful on it. Some
Capable of performance by the parties. I mean, if the party is not capable of performing the award, if the party is bankrupt, and I give a cost to the party, what can it
for that, in that award itself, there will be some aspect of security for cost. Can you recollect? Before that party in the arbitration process, the tribunal would have issued a security for cost.
In fact, one of
If
the
they
parties
anticipate.
will make an application.
Yes, application. There will be a scenario wherein the security for cost would be there. That
has to be?
makes the party to perform. The capacity is automatically there. If nothing is there, you can't do anything. Fine. Some guidelines, I have just given some guidelines, and subsequently all these presentations are based on that. I will quickly go into it. 1. Initial consideration. 2. Modalities of making the award. It is just an expansion of this earlier. Basic points on drafting the award. Nucleus of the award. Outlook of the award. Finally, sometimes award by consent. When it comes to initial consideration, what is the role of institution? The requirement of place is very much essential. The fundamental principles and the compliance of those, that is the applicable laws, governing laws, and further interim awards and procedural orders. Coming to modalities of making the award, timing and approach. Why the date of hearing and procedural matters are mentioned? In India now we have a time frame. An award has to be given within 1 year or maximum 18 months subject to extension of parties. That is why timing and approach. If an award is given beyond that, the validity of an award would be questioned. Don't give a chance. Clearly mention it. Timing and approach. Arrangements for tribunals of 3. How the 3 is going to prepare the award, who is going to sign. Then the times for deliberation, the procedural hearings we had, no? Those times of hearings and deliberations. Submission of draft award when it comes to institutional arbitration. These are some modalities. If it's an institutional arbitration, the rules mention that, according to Article 33 of ICC, says that the draft award before publication has to be shared to the Secretariat. That requirement is very much mentioned here. Participation of all members of the tribunal. There might be some hearings wherein there will be sometimes the quorum won't be there. One arbitrator would be absent, he would say over phone that you continue the hearing. That also mentioned. In the particular hearing, only 2 arbitrators were present, one was not there. With his consent over phone, the hearing was conducted. Languages. Sometimes the award should be bilingual, but in your examination it doesn't come generally. Then confidentiality of the drafts. Basic points on drafting the award. Need of the parties, clarity, precision, brevity and ease of use. Annexing documents. Okay. An award, whether it can have annexures.
Mostly I think it should be avoided. Because that's the whole idea of you putting everything in the award. Unless there are some mathematical real calculations and other things.
Like an addendum or a
then you don't want to bother in between the reading of the facts. Then you put that as an annex.
Fine.
Like quantification of damages or something like that. It's a huge matter.
It is very clear that an award should not have annexures.
First, avoiding is the first.
Maximum award. If you want to mention anything, you produce inside the award itself. Don't make it as an annexure. Avoid putting annexures.
Because there are chances that parties are cheating also. Sometimes they put a separate paper as the annexure when they go to challenge and all that. So
the final page of the award should not have enclosures.
we faced a scenario like
this.
In the 34. He completely changed the annexure itself. The calculation.
Possibilities are very high. One small award is based in facts and documents submitted. Why annexure? Okay, already Sridhar has a doubt. But I wanted to mention this, that we have to avoid annexures. Not required. Discussions that are relevant and decisions. If you had any discussions, that discussion doesn't presume that discussion with the parties. Discussions with experts. If in your arbitration, if there was an expert appointed by the tribunal, reproduce that report or important portion of that report wherein the arbitrator had a discussion and come to the conclusion. That portion alone. And decisions that are not relevant. Fine. Nucleus. Objective, reasons, point on order, facts, law, application of law to the facts and alternative issues. Outlook. This is the macro. What is a macro? Claims. Some engineering contracts might have several claims, list out claims by numbers. Cost. If there is a demand for cost, if there is a security for cost, if there is an award on cost, categorize all the 3 in different categories. Then final formalities like place, signing and date of the award, corrections and interpretations. If it is an institutional arbitration, this correction and interpretation comes. Otherwise, it doesn't come. After publishing only, the parties might raise those. And if it is an award by consent, till date, we are not seen in this award writing examination having an award by consent. If it is by award by consent, it is very easy for you. Just 3-page. Make that a settlement as such included in the arbitration and give it. But as a structure, I just made it.
Structure and then
just
settlement point.
All the technical aspect. First put the technical aspect, then the abstract of the settlement deed or whatever, then your final decision, signature place. That's all. That is a very simple structure. That's what is mentioned. General. Conditions for an award by consent, parties agreement, further agreement necessary to assist the parties, examination award by the tribunal, refusal. Here also, an arbitrator can refuse. Can refuse accepting the party's settlement, and they won't be interested to give an award on consent. That is good. Look, sometimes both the parties would agree for an illegal object. They smartly comes, but you should not sign and give an award by consent. Okay, there is one question by Sridhar. Can we, after mentioning all the technical aspects, draft the award issue-wise like the judgment of the law? Yeah, that is left to you. It depends upon individual. You can also do it. That gives a good structure of that award. After discussing all the technical aspect, then mentioning the issues like normal judgments. That's what initially itself I was mentioning, that look upon some judgment. That gives a template or a format for an award. Issue-wise, I mean deal and decide the issues one at a time. Fine. First, list out the issues, then give the answer analysis for each and every issues. Issue 1 to 10, you list it out. Then come to the analysis part, wherein issue number 1, mention the issue, then bring down the facts, then your reasoning, then the legal provisions as well as the contractual terms, then your conclusion. This is a normal one paragraph of deciding on the issues one by one. It's normal court practice you can use. If you are a lawyer, if you are non-lawyer, you just adopt these simple proportions. List out the issues, answer each and every issues with facts, relevant legal provisions, relevant contract, then your reasoning. Reasoning might be 1 or 2 lines, then your conclusion. And finally, the operating decisions. Yes, I think I have reasonably covered all the aspect of structuring an award. Beyond that, we are not allowed to disclose. That is the reason why in this PowerPoint presentation, also the last slide I have included that anyway it is going to be ever-ending, is really just a new beginning. That means your examination is the beginning for you in your career. But this award rating examination is really a tough task in this entire course. But once you are comfortable with all these, if you are very clear that you are going to reproduce whatever you heard, and you are not interested to go before the courts under section 34, then your award would be a good, effective award, getting a good marks.
So just for a matter of looking at different awards, like the reading material suggests that there are 8 kinds of awards.
Okay.
One, you said award by consent has never been asked. The other, we can expect questions on. Like
no, I'll try to traverse beyond my authority. It will be a contested award. It will be a final award. Nothing beyond that. As of now, that is the way how they are making it. Normally, it comes in the European jurisdiction laws. It can be a domestic arbitration of that country also. That might come. But you just think upon that checklist. Try to keep it in mind, that checklist alone. Make it. And whatever technical inputs and this judicial inputs has been given, that also have another checklist, whether you have answered all those things. You might be wrong. Your decision might be wrong, no need to worry. Try to justify that position, that is enough. It is not the examiner going to in-depth on finding all these, whether you are right or wrong. Whether you have analyzed, reproduced in a structured manner, that is very much required. That is the very purpose of this award rating. One more thing, can we get our own material in the award rating?
yeah, it's open book, so anything.
Get our own material in the award rating examination? Yes.
It's open book. They say
Open
you can
book.
bring any material.
But within that 4 hours, if you are going to look that, you can't complete. Mr. Sridhar, you have to be very cautious.
What material you are using?
What material beforehand you share with me. Whether it is advisable to look upon that or not, I'll just suggest. But simple reading is that have one judgment, this checklist, and answer it. And when you are going to prepare this first portion of that award, there itself you can reasonably understand how it is going to go with. Okay. Any further doubts, notes? Oh, modules, notes, PPTs. Yes, all are allowed.
how it is submitted? We just email it or after we come?
It will be email or physical copy, whatever might be. Mostly email. Email, right?
PDF.
PDF or even Word would be better. Anything that is left to you. But all the instruction will be given when the time is being shared. But the time 10 days is sufficient, but 4 hours is insufficient. It's really insufficient, like doing an IIT exam. We had to complete.
Ideally, the prior 10 days before what they give us, it is better to prepare in that 10 days itself.
It's very simple as that. That 10 days is entirely for a revision. We have to prepare. Just spend 1 hour a day. You can complete it. Maximum, I'm saying, 1 hour a day.
We are not that familiar with these judgments. So if you can tell us 1 or 2 famous judgments, what we can refer to.
Judgments mean I'm saying any judgment. You might come across day to day many arbitration cases in your company itself. Some judgments in the case they would have somewhat highlighted. That judgments you have a look just to understand the structure. It is left to your own, but to make it appealing, you just look upon that. And some 4 to 5 awards have been given, no?
The material one is
Yeah. All these materials would give so much of inputs. So you would be going. An extra. Mr. Venkatrao, Rangarao, I couldn't understand. Can you just repeat it? Interaction. அது நம்ம கனெக்டிவிட்டி ஸ்பீடுக்குலாம்
அப்லோட் ஸ்ட்ரீம் வந்து 30 MB
இங்கே கால்குலேட் யார் ரொம்ப வாங்குறது இல்லைங்க. Mr. Vijayan says 4 hours not enough. We are getting an extra hour. Mr. Rao, the official time is only 4 hours.
Beyond that,
you had beyond that. If you are going to go, if Mr. Some top authority is here, you will be screwed.
For that you go to London. Beyond 4 hours you go.
You can complete. You can complete. You are engineer. I think Mr. Rao is an engineer. Venkat Rangarao. It's easy for you. You can even complete within 3 hours. But if you are going to use a laptop, you just prepare with your headings beforehand. Make your preparation of the headings so that you can put all the inputs.
Put all your checklists in place.
Yeah. He got it. But the 4 hours can't be extended. That is the final maximum period what has been given. But anyway, I think within this reasonable time, I have shared some inputs about structuring an award, particularly the award rating examination. And further doubts, you just look on rate earner, ARB 40 award rating tools. And you have to have your own self-study on it. And best wishes for your examination. Anyway, on 17th, this video will be available on the YouTube channel, Sridhar Mehta.
Please.
I think Mr. Sridhar, it will be available only till 5 p.m. 10 p.m. Till 12 a.m. 12 a.m. And if you have the capacity, you can just save it or download it.
Do you give us a link for that, sir?
A link, I think it will be shared. It will be shared.
The link will be active in another half an hour.
Okay. Anyway, just any further clarification you have, I think most of you would have my emails. Just drop me a mail. I'll respond whenever I am free. Some more questions are there. Thanks, Mr. Jim. Looking forward to see you on 17th. Okay, fine. I'll be the examiner, Mr. Rangarao, on 17th. Mr. Nishikant, where do you get ARB 40? ARB 40 award writing tools is available online. Anyway, I'll also share. Sometimes it won't be available free of charge. You have to subscribe. I have a copy. I might share with the organizers so that they will share with all of you. But it is also just like a supplement or a add-on with rate earner. Okay, thank you all. And one more question I think Harita wants to ask.
Here can we can we restrict ourselves to Indian Arbitration Act, or because here the material we have UK Arbitration Act also, because it's an international arbitration?
No, I wanted to mention that it can be either domestic or international. Even if it's a domestic, it might be a domestic of Ireland, Irish Act, or the UK Act, or even a German Act.
So we have to be conversant with.
Your materials would be given. The annexures, what has been given, would have an abstract of the law provisions, or it might guide with the model law, whatever might be. All those documents with the inputs would be given. If it's not there, you need not answer that.
Because I was wondering if we can't have everything, all the abstract clauses meant to reproduce from this.
Mr. Nishikant, location in Mumbai, I think you have to check with Mr. Kamdar. Most probably it might be MCIA office, Mumbai Center for International Arbitration, Express Towers in Kolaba area. But you write a mail to him and get it confirmed. Okay, any further doubts, you can just drop a mail, and I'm happy that there are limited queries, and we have reasonably just conveyed and how a structured award, an acceptable award, has to be reproduced. Thank you friends, and best wishes for the examination. You have a lot of time. Whenever you find free time from your professional commitment, just have the reading on that written relevant portion, as well as Julian Lew's material, and one award. You have a thorough reading, how it has been structured. Don't take into the serious content of it, the structure alone. Make a preparation of it. I shouldn't say that, but it's good. You make the headings alone prepared, so that you can put the inputs. Wherever required, you put it, or else you just remove it.
So that you won't miss out the
Yes.
structure of it.
Yes. Thank you all.